Hey, welcome back. Carl Rominger here. Getting some interesting emails on this healthcare bill. Now, somebody just alerted me not later than 36 months after the date of enactment, you're supposed to get your personal information with tracking capabilities linked to your bank account and something about an RFID tag as part of the healthcare bill. Some kind of requirement there. Now, who writes that into national legislation? I don't know. All right. Anyhow, let's talk about this assessment in Lebanon County, because I think we have somebody knowledgeable who's calling in, and that's what I like, guys and ladies. If you know more about something than I do, which is probably most of the time, feel free to call in and help us out. Tim, you're on the air with Carl Rominger.
Good afternoon, Carl.
What's going on in Lebanon County? What should the callers know?
Okay, well, and just to put this in context, I'm with the reassessment office in Lebanon County, so I'm involved in the reassessment process over there. I caught the tail end of your previous caller. It sounded like he had been to the informal review, and at the informal review, they can only verify physical description. If there's a debate about value, that has to be done before a formal appeal board. So you've got a panel of 3 people. There will be an appraiser from the county or our staff present for that. But at the informal review, that's to catch the obvious errors, things where the description isn't right. There's things that we did not know about the property. Right. In the mass appraisal process, it's a batch procedure. You're not going to know as much as the property owner does. So the informal review, we encourage everyone to do that, because if you don't have the right data, the appraiser's not going to have the right value. If that doesn't result in the value that the property owner believes that it's worth, then they need to go to the formal appeal. They do, no disrespect meant to the attorney profession, but they don't actually have to have an attorney at that. It's a lot like what you've experienced in Cumberland County, which we've also been involved with over the years. Their goal at the formal appeal is to get to the right answer, but they can't make those kind of judgments at an informal review.
At the let me stop you for a second. At the formal appeal, when this guy comes in with his appraisal, does he have to have the appraiser there, or will you guys accept the appraisal without testimony?
Absolutely does not have to have the appraiser present. Very rarely are folks bringing in experts or testimony. The only stipulation that you would see at a formal appeal is the property owner themselves must be present. If someone else is representing them, they need to have a limited power of attorney to state to prove that they're able to represent that property owner.
Right.
But if the property owner is there, they can present that appraisal, even the bank appraisal. They will look at that. It's not as useful as a fee appraisal that's been done with an appraisal date of January 1st, 2012 to match the reassessment based on current sales. That's a better, more useful appraisal, but anything they have that they believe, including their own research, because all this information is available on the website, so the county property owners can do their own research if they want. Whatever they want to present. But 2 main tips I always give folks. Number 1, come to a formal appeal with an opinion of value. Be prepared to answer the question, what do you think it's worth? Reasonable number. What do they believe that it's worth? And number 2, have some evidence or justification to support that.
Right.
And if they present that kind of information, there's no incentive for the Board of Appeals to keep values high, because when a reassessment is done in an entire county, the millage rates all get reduced to exactly balance it out from a revenue standpoint. So unlike annual reassessments or annual appeals, this is very different. This is a countywide process, and there's no money to be made through it. It's just a matter of trying to get the right balance from one property to the next.
Right, and that is an important point, which is there's not going to be any incentive not to use the values, because all that's going to happen, like you're saying, is it's going to push the tax around a little bit differently, but at the end of the day, the same amount of tax is going to be collected, so it's revenue neutral from that standpoint.
Absolutely. Absolutely.
Now, Tim, one last question for you, and I'm going to let you go. After they come in and they do this informal appeal and they're still not happy for some reason, again, that was my impression is in most of the counties, the informal appeal process usually works very well. Or I should say the formal appeal process works very well and resolves a lot of them. But say we do get to the point where we have to go to court next, how long do they have from the time of the formal appeal to file an appeal to the court?
Okay. Well, they have 40 days from their original notice to file to get a formal appeal before the county board of appeals.
Right.
And then the first deadline for that's the 25th of July. They must go through that appeal in order to go to common pleas.
Yep.
When they are denied, or for that matter, if they get a decision that they're not happy with, let's say it that way, from the formal appeal, then they will have, I think it's 30 days.
Sounds
I'm
right.
not 100% sure. I believe it's 30 days from the notification of that decision to file with the Court of Common Pleas. And there's plenty of opportunity, to do that. And maybe it'll get resolved at the formal hearing, and they won't need to go to Common Pleas. Very few do. But at that level, if they're going to Common Pleas because it is a court proceeding, it's a tax appeal, not a legal, not a criminal or civil case, but it's absolutely advised that they get legal help with going through a Common Pleas appeal.
Yeah, they're going to follow. They're going to generate their documents. They're going to have to follow the rules of evidence. I mean, the whole 9 yards. Okay, so Tim, thank you very much. I hope anybody in Lebanon County heard what you have to say. To summarize, is informal appeals are basically, hey, you got my lot size wrong, or it's a 1-story, not a 2-story, so there's an obvious problem here. Come out and refigure it. The formal appeal process is I have an opinion of value different than yours, and I'm prepared to present some proof of that and argue why my value should prevail. And if you lose there, then you file the attorney, and the attorneys try to do the same thing, but you better have more than $10 at stake at that point.
That's a good summary, absolutely.
And finally, one final summary, which is, by the way, this is the one time when there's no incentive, arguably, even if there never is, there's no arguable incentive for the board to not want to just figure out best case scenarios for these houses, because it's going to be a revenue neutral scheme. So while you may reduce your tax, it's going to just get pushed across the the equalization rate or whatever you call it?
The millage rate. Yeah. The millage rates will come down. We estimate that the values in the county went up 7 to 8 times, so the millage rate will come down about 7 and 8 times, but we won't know until November what the final break-even is.
Got it. Thank you very much.
Absolutely.
540-0580. Carl Rominger here answering your questions and straightening out the Lebanon County appeals process for anybody who's listening. Jeff, you're on the air. Hey, Jeff.
Yeah, I got a landlord-tenant problem. I got a tenant that had a severe water problem and left to go for about 2 months, and the wood got dry, rotted, and moldy, and all this stuff. So I'm tearing the bathroom out, redoing it, doing it right. And the person next door, I own the property next door, and he's not there for a couple months. She has free, she can come and go if she wishes to take a shower, go to the bathroom, do whatever she wants to. Is that considered me still supplying her services? The fact that she doesn't have a bathroom in the house, but next door she can come and go, and it's on her own. Nobody's home. She has a key. She can come and go if she wants to. It's like 15 feet away.
So she has no bathroom for the moment.
Right.
And how long do you think till you'll have it fixed?
Well, it's going to be 2-3 weeks. Could be longer because she just called it. Excuse me. She just called the cops and said I was harassing her. So that's going to slow things up considerably. So I can't really be there without somebody else. So I'm thinking about evicting her. So that,
right.
I mean, if
she can certainly break. If she's in a lease, she could certainly get out based on the fact that there's not an available bathroom. Although you're saying I'm making a porta potty basically available to her, which is
it's a 3-bedroom ranch house right next door, 15 feet away. The guy isn't home for a couple months, and she has the key. She can take a shower, go to the bathroom any time of the day she wants to, like it's her own house right next door. Is that considered supplying her with services?
I think it would make as long as you're legitimately endeavoring to repair something that needed to be repaired.
Well, I'm tearing it apart. She's upset because I'm tearing it apart, but I got to tear it apart to fix it.
Yeah, you should follow me when I'm just saying as long as it's legitimate, I don't see the issue. Although, theoretically, it's a good time to let her out of the lease if she's accusing you of harassment.
Well, I want to get rid of her, but she doesn't want to go. Even though she's upset, she doesn't want to go. No, I can't.
Well, God bless her. All right, Jeff, you get the idea. I think you're close enough, but if that's her issue, then she's free to go.
Okay, in that situation, 10-day notice to quit sufficient?
Would be.
I mean, the fact that she has utilities right next door, she doesn't have any leg to stand on, is what you're saying.
I think you're A-okay.
I thank you very much.
All right.
Bye.
Got to go to break. All right, guys, by the way, if you're joining us, just remember you can hear all about the Lebanon County appeals process for those assessments in the podcast. Just go back and listen to the top of the show for hour 2. and you'll get it. 540-0580. Carl Rominger here answering your legal questions. We'll be live on the air until 3 o'clock, so bring it on. You guys want to talk about health care a little bit? You want to talk about whether the Supreme Court was right or wrong? You want to talk about whether you think John Roberts is still your WHP 580 hero? Dave, you're on the air.
Hey, Carl, how are you today?
Good.
All right, I'm over here in Fredericksburg. They're running sewer and water. I'm on septic right now, but they're going to rerun in sewer and water pretty soon, and they want access. I guess the township solicitor wants access to my property, a 30-foot swath of my property,
right,
to lay the main. I got this letter this week. They want to give me $479 for, I guess, access in perpetuity. Is there any way I can negotiate that, or is that just something that's going to happen and I have no say in it?
It's funny. They'll come in and eventually use eminent domain to get it, right?
Yeah, sure.
So at the end of the day, you take it that way. We've negotiated them before, sometimes ask for a little extra compensation if there's offering any kind of compensation. The one that I did one time years ago, and this was just something I did to chuckle, was that we limited the right-of-way. We inserted language that said that the right-of-way was limited to only for use of the sewer and no other purpose.
Right.
Because I don't know if you remember this or not, but there's a lot of these right-of-ways that have been negotiated over the years with people where the power company comes in, and then all of a sudden they run a high-speed data line and 8 different other things through the right-of-way, and everybody who owns the right-of-way, which is the power company, gets rich, and all the original landowners get nothing.
Right.
So I thought about throwing that in one time, but my advice would be just live with it.
Just do it. Because
yeah.
The reason I was wondering about it is because we got a perfectly good septic system. You know, everybody's complaining about that, of course.
Oh, you're going to have a mandatory tap. That's the problem.
Yeah, well, we were off the easement, or the 150 feet, but the way they're going to run the pipe through my yard guarantees that I will have to hook up. And you don't think there's any... You can't fight City Hall on this thing, huh?
Generally not.
Okay.
All right, my friend.
Thank you very much,
All right,
Carl.
take care. Bye. Which, by the way, that goes back to this whole concept of what can government make you do? Well, they can make you hook up to the sewer. And here's the theory. Everybody uses the sewer, right? I mean, sooner or later in your life, you're going to need to use the sewer. So government can make you hook up to the sewer. Is it really any different than health care? I mean, is it in the final analysis very different? Well, the only difference in this question was, could Congress do it, not could the state of Pennsylvania do it. So the state of Pennsylvania can make you do anything it wants you to do, essentially, as long as it doesn't violate the United States Constitution. And Congress is limited by the powers enumerated in the Constitution. So the only question in the Obama health care, John Roberts Supreme Court issue we all know so much about now wasn't whether or not the individual mandate was a possibility. The only question was whether or not the individual mandate can flow from the federal government as opposed from a state government. And if all 50 states have an individual mandate, then I guess it doesn't matter where you go. It doesn't matter if you switch states or not. Now, the Medicare issue that's going to come up, we should talk about that. The question is going to be, will Pennsylvania expand its Medicare coverage? And that's an interesting question that Governor Corbett's going to have to wrestle with, because he's probably the one who's going to have to make that decision. But once we sign on to that, it's going to go up forever. So 540-0580. Jim, you're on the air.
Hi, Carl.
Yeah.
I have a question about probate. My mother is 82, and my brother and sister both passed away, and she had her will set up so that each of us would get a third of her estate when she passed away. I think she had a clause in there that said that if my brother and sister weren't there, that their children would get their share. Mm-hmm. And I wanted to ask a couple questions about probate. I wanted to know, first of all, should I get power of attorney in case she'd be incapacitated and I'd need to make decisions or sign documents on her behalf?
The short answer is that's what a power of attorney will let you do. So it ceases to exist when somebody passes. So power of attorney helps you through periods of competency or incompetency to assist a loved one or a friend or whoever you're the agent for.
Okay, and then the second part of my question is, as far as whether we would need to rewrite the will, can any attorney handle a probate equally well, or should I go to someone who tends to specialize in probate issues?
Well, here's my feeling on it. If the lawyer's familiar with how to write a will and has done a lot of them, I wouldn't see an issue with it. If it's their first will, maybe that's a better idea to let them write wills for 30-year-old couples at that point. But there are estate planning issues, and there are things you have to worry about when people are older. And, of course, it has a lot to do with the amount of property. So I feel very comfortable, for instance, writing wills for people that have relatively decent net worths. But if somebody walked into my office and is worth $100 million, I'm going to send them to a specialist who can help them, squirrel all that money away from the federal government. When they're only worth $3 million, then the issues are much different. On the other hand, and we're going to have one of the guys from Keystone Elder Law on here, I think in a month or so, and he's going to talk at length about all the other considerations out there, which have to do with nursing home care and Medicaid eligibility and all those things that have to be thought about at this stage too. So,
yeah, to get an attorney who works closely with financial planners. I know she has a financial planner who handles all her investments.
Mm-hmm.
And he had suggested someone in his area that he knows that does probate work. Is it a good idea to have someone who works closely with your financial planner to make a smooth transition of all assets?
The answer again is it depends on your comfort level and how involved you are with your financial planner. And the short answer is no, that's not bad advice. In other words, if you've got a CPA and a financial planner and a lawyer and they all know each other and work together and they all kind of know each other's style, it's helpful, so that way there's a better communication and a better ability to figure out who really means what. And it says in anything in life, if you know somebody, a lot of times it's easier to figure out what they're trying to tell you, or their personality type. So when they tell you something, what they're really getting at. So yeah, I think that would be beneficial. I don't think it's absolutely necessary. The flip side is of course, there's a countervailing argument, which is all the eggs in one basket. And so if you hire my best friend who's a financial planner and my best friend who does this and my best friend who does that, we're not going to be very critical of one another necessarily. That's not always the case, but there would be an argument that having people that are too close or too chummy, or they're just trading business back and forth, they might not be in a relationship where they feel comfortable criticizing each other when necessary.
Okay.
So there's kind of two arguments to that, but it's sort of like anything else in life. Sometimes in hindsight, one's going to seem better than the other.
Okay, very good. Thank you very much, Carl.
All right, Jim, take care.
Bye-bye.
540-0580, Carl Rominger answers your legal question. Now, you think about that for a minute. There's always these arguments on both sides. I want all my people to work together and work closely together because they're going to be more efficient. Quite possible. Or I want all my people as adversaries and opposites of each other so they're cross-checking each other to the point of annoyance. Maybe expensive, maybe unnecessary, maybe detrimental. Either scenario best evaluated later when the result is known. Gary, you're on the air.
Hi, Carl.
How you doing?
I'm doing pretty good. I got two accident questions. I was involved in two separate accidents. The first one happened on April 20th.
Okay.
And the policeman told me that I was going to be cited. I haven't heard anything yet. Is there a statute of limitations, or can he send me a ticket anytime?
A traffic ticket's supposed to be is issued as promptly as possible, but there's an absolute bar of 2 years.
Wow. Okay.
Yeah.
Wow. Okay. And the other one, I had a guy just a couple weeks ago take a left turn in front of my motorcycle.
Ooh.
How do you figure out tort? Is there a scale? You got this many cuts, you get this much money.
Here's the answer. Valuing them is difficult. In fact, I was talking to a female lawyer who I'm very close with yesterday about this, and we were trying to talk about the value of a case. And the short answer is it's not a linear question because there's so many things that come into play. And so, if the client, all things being equal, and one client was this active, vivacious person who's now not doing anything anymore versus somebody who was a couch potato to begin with and is now just still a couch potato, that alone can change the calculation of damages. Uh-huh. So the other thing we look for is broken bones. When you go in front of a jury and the theory goes, and you can show them, that compound fracture, the one that picture that goes, ouch.
Right.
That has a palpable effect. Whereas if you have an equally terrible injury, but it's soft tissue and some kind of swelling that an MRI really kind of can show, but a tech has to tell you what it means. And by the way, there's a chance that was a degenerative disease that might have been there before, even though we all know it wasn't. There's still an argument that can be made. all of a sudden your settlement value goes down. I will tell you this, however, I've had a few motorcycle accidents over the years, and one of the ones that comes to my mind was a police officer who got hit while he was riding privately, and he worked the insurance company up to $7,000 right on the eve of the statute of limitations. And he had started at $2,000 with him and kept working him up, and we had an agreement that if he wasn't happy, he was going to hire me right before the statute, and he did, and we got him up to about $17,000. And he said to me, "How fair is that?" And I said, "Well, the difference is I know what the adjusters want to hear, or what they have to hear sometimes to get to a certain point." Right. So those are all considerations.
Because I walked away. But I had, bruises. I walked away slowly.
Yeah, no, I know.
I mean, I kind of think I should expect something, but...
Yeah, you certainly... Now, if you had a limited tort or full tort auto policy...
It's full.
Full, so there's no rubs there. My thought on the matter would be it's well worth pursuing. The question is, how much is it worth? And if they don't want to give you, enough, then come see a lawyer. I mean, we'll always take a third or 40% on a small case like that. And,
okay.
Gladly, make a little money for each of us.
Okay.
All right.
That's what I need to know, sir.
All right. Take care.
Thank you.
Bye. Got to go to break. Welcome back. Carl Rominger here, 540-0580. Answering your legal questions this afternoon. Brian, you're on the air.
Hello.
Hey, Brian. How are you?
Hey, real good, Carl. How are you doing?
Good.
Hey, Carl, I've got a quick question here for you. I am executor of my mother's estate. We're on the final leg of it where there was some financial things we had to take care of. We're about ready for distribution to my siblings. Now, I got a quick question. I know the law says I have to distribute this fairly among the six of us. But my other question is, all my siblings know that my mom desired a portion of this to go to charity. Though she did not have a will and they have knowledge of it, do I still have a privilege or do I still have a right to honor my mom's wishes?
No.
It's a small amount of money.
No, you don't, unless they all agree.
Okay.
Because you were appointed with letters of administration where you swore an oath to the estate, and you have to follow the laws of intestacy.
Okay.
So now, if all the siblings agree, then yeah, you could do it.
Okay, well, I have another question then. I've been told that because I'm the executor of the estate, there's a percentage that I'll get for being the executor of the estate.
You are entitled to a fee, and you could take that fee and you could give it to charity, yes.
Okay, so how much is that fee?
Well, that's an interesting question. That fee can be anything. And it's what's reasonable under the circumstances. And in some cases, people use a percentage. In other cases, they use hourly based on the work. That's something that you and the attorney who are doing the estate should probably discuss or have discussed. But there is also a safe harbor out there, which is a decision called Somebody's Estate, which has some numbers in it for percentage points for the executor.
Okay, so I could ask for that percentage and then give that to charity on my mom's behalf.
Right, you could get donated in her name and accomplish it. But if the other thing is, you could tell the siblings, I just want to give that percentage. So rather than call it that, because what you want to do is avoid capturing it, having it become yours, and then you give it away because there would be a tax. So not as a small amount, but technically it's income to you, taxable income to you, and then you're going to donate it. So you may want to sidestep it.
Okay. What was that again?
You may want to just talk to your siblings and say, hey, I was going to take a 3% executor's fee, but I'd rather just donate it to charity in Mom's name so everybody agree I can give 3% and we'll divide the rest.
Oh, okay. So then that way I don't have to pay tax.
Right. It doesn't flow through you. It flows out of the estate.
It flows out of the estate. Okay.
All right.
Okay. All right. Thank you very much. It makes much more clear.
All right. Thank you. 540-0580. Carl Rominger answering your legal questions. John, you're on the air.
Hey, Carl. I had a speeding ticket that I went to ask for a hearing for.
Yeah.
And it went pretty well in my favor where they knocked it down considerably. But my question was, the original officer did not show up for the hearing, another one showed up in his place. And I was going to fight it, but he said, we'll just ask for a continuance. But they made sure I had to give 48 hours notice before, if I was going to cancel on the hearing.
Yeah. I mean, here's the problem. They changed the rules a few years back to make it clear that the non-attendance of the officer alone should not be reason to dismiss it. Notice they say alone. So we always argue prejudice, like, I'm here, Judge, we're ready to go. My client's prejudiced because he spent money on an attorney. So some judges will, some judges won't dismiss it.
Okay.
A lot of times it has to do with the officer's history, too. What I mean by that is if you're a district judge and you have a cop, a police officer, a game warden, or somebody who's always prompt and always on time and is always there, and the one time they're not there, well, they're probably not going to dismiss it because they assume something legitimate's going on. If they have somebody else who writes a lot of tickets but only shows up for half of them, then they're probably just going to dismiss it.
Now, they said, this was the judge's reasoning. He said, the state police write so many tickets in this area that if I had every officer in here, I'd have 18 officers in here for the hearing.
Right.
And
so what they do is they just throw in, see who shows up, and try to negotiate them out.
Yeah, they have two. They'll have one officer for the whole department, and then he sits in there and negotiates them out.
Well, it's called practical justice.
Right, but I was really disappointed in our justice system that day because it was just like a cash register ringing.
Oh, I've said this on this show many, many times. Speeding tickets, speeding tickets are a moneymaker for the state. That's all they are. Nobody really cares, and I know there's a bunch of people out there going to get mad at me, right? But nobody really cares if you go 80 miles an hour. In fact, the fact that people are driving 80 miles an hour on 81 is not really costing arms and legs and life left and right. On the other hand, it is definitely making the state a pile of money. And so if they really wanted driving at an excessive speed to be illegal, they would make it clearly illegal and punish it like a DUI or punish it like something else, right? And then all of a sudden people will be like, whoa, I better slow down. I don't want to go to jail for 2 days.
Right.
But no, what they want is they want the enforcement mechanism thin enough that you can speed most days and get lulled into a false sense of security so you can get pinched every once in a while. So all they're looking for is a way to squeeze an extra $180 a year out of the average driver, right?
Yeah, that's what. And the judge said, I was very polite and nice about it, but he said, well, I don't have time to hear a case today.
Yeah.
We'd have to reschedule it. And that's what I called for, was a hearing.
You got the squeeze, my friend.
Yeah.
The squeeze. And, but you know what? At the end of the day, if you push back on the squeeze, things often don't go well. And that's not a great answer, right? But it's the political reality of that situation. Fortunately, we have a safety valve for that, which is if you did try to push back and you thought the squeeze was being unfairly squeezed tighter, you can at least go to the Court of Common Pleas on a de novo appeal within 30 days of the conviction of whatever the district judge does. But I think you'll find that what they were trying to do is sort of say, okay, we're just going to collect our money and we're going to try to give you as few points as possible. Now you just cooperate.
Right, and that's basically what they did.
Or as Bob Durgan would say, bend over.
He would.
All
right. Thanks, man. Bye-bye.
540-0580. Stephen, you're on the air.
Hello, I'm calling from Mechanicsburg. I own a piece of commercial property, an acre.
Okay.
The building sits in the middle, and I have a back, front parking lot and the back parking lot. I started, but the property next door, when I sold it to them, I put a front and a back right-of-way in. So about 3.5 years ago, I started to put use that right-of-way because I wanted to put parking in back of the building. And the people next door harassed me, and then they sent me threatening letters, and it's to the point now where they put up a fence and chains, and it's a restaurant next door, and they put up their garbage dumps, the heavy metal ones, in my right-of-way, and I have no access. Now, it's in my deed. They know it's in my deed. We've written them letters. I've had attorneys, but every time that I have attorneys, they just write letters back and forth.
Yeah, it's time to file a relief equity action to order a court to restrain them from blocking your right of way. And that way, if they do it in the future, you have the power of contempt, and they can be jailed, fined, and you can get your attorney's fees.
All right. Well, where do I start? With an attorney?
Come see me.
Again? Okay. All right.
Come see me, but we're not going to write letters. We're just going to file suit.
Okay, that's good, because they've been really mean and nasty. They've even cursed and swore at my secretary about it. And I thought, well, at nighttime I'd go in and chop down this fence, but it's on their property. So, Okay.
Little self-help. No, they're doing self-help. Right. Why not you, right? Well, that's why we have a system of laws, fortunately, to prevent everybody from doing self-help and eventually clubbing each other to death.
Good.
All right, my friend.
Okay, thank you. I appreciate it.
No problem. 540-058. I just want to tell you guys I'm going to be on CBS 21 tomorrow at 11:30 a.m. It's Face to State with Rob Hannerham. So if you get a chance, tune in 11:30 a.m. tomorrow, CBS 21, and you can hear me grilled. See you after the break. Art, I just took a couple of those pills they were talking about. What's going to happen to me? I'm going to... Apparently on this radio station, if you listen to this radio station, you have problems. You need fish oil for your heart. You need something for your prostate. You need something for your, you know what. I'm just going to start making a list. And then if you stay up late at night, you talk to aliens. So I am proud to be a part of this operation, I just have to say. I mean, where else in the world would I fit? Megan, you're on the air.
Good evening, or good afternoon, Carl. Oh, gosh, you make me laugh. That's true. And you talk about aliens at night. Yes, it is a crazy station. But you're so darn entertaining, I got to tell you.
Well, thank you.
Whatever.
Oh, now Art's getting in on it.
Oh, what's his 2 cents?
Well, he's got buttons over there he can push. All right, what do you need to know?
Hey, listen, I do have a serious issue. I've got an absentee landlord situation. I have lived very quietly and I've been a very good tenant for 4.5 years. Mm-hmm. However, I've got about 1.5 by 1.5 hole in my ceiling, which leaks intermittently for the last 4.5 years. And my landlord is a retired, should I say, disabled MD out of Maryland, right? Mm-hmm, mm-hmm. And he lives in, a nice gated community, and the rest of us up here, we can't get him to, fix squat. Anyways, this has cost me 2 beds now because the only place that I can put my bed is below this hole. And I'm not an engineer, but I have a carpenter's grade garbage bag maneuvered over this hole so that it drains to the side when it intermittently leaks. And he owns this house and the house next to, which his son lives, who is a handicapped gentleman. Mm-hmm. And he just, in his last email, he won't hire anybody to fix anything. And I've, in the past, had to put my rent in escrow in order to get him to fix another very dangerous issue. So in his last email, he intimated to me that he's been there 6 or 8 times and it wouldn't leak for him on command, so I was free to move at any time if I so desired. So, I don't want to leave where I'm at. I'm comfortable except for, like an issue like this happens, but I don't want to have to be looking over my shoulder to say, for him to come around sometime and say, oh, you're just causing me too much trouble, move on, little girl,
Right.
So what do you do?
Well, my answer is you start looking for a new place to live. That's answer number 1. In the meantime, you can withhold the rent and put it in escrow, or you could do the repairs yourself and just deduct that from the rent, although that's risky. The escrow solution is usually a good one, and it tends to prove to the judge that you had the money.
Yeah, it motivated him to fix the last issue. It's been this.
Right.
This is the only thing. Other than that, I love where I'm at, and I love my neighbors, and I really don't want to move. I don't want to tick him off to the point where he makes it more uncomfortable for me, or finds a reason to, because we're on a month-to-month now, I guess, because I've been here so long. Right. But my rent has never been late. I've done so many upgrades to his place. So, I just, I don't want to rock the boat, but I'm really sick and tired of this.
Yes, you're probably gonna have to deal with it. So that's my advice: is use the escrow again. And if that doesn't work, in the meantime, though, I'd have an escape plan, because it sounds like you're the landlord that this is going to repeat. Listen, okay, this is like your husband, and he's cheated on you twice.
Honey, that wouldn't have happened. The first time he would have been gone.
Well, there you go. Then you already know what the answer is. All right, Megan?
Okay. All right, thank you so much,
take
Carl.
care.
Bye-bye.
540-0580, Mary Lou.
Hi, Carl.
How are you?
Good, how are you?
Good.
My question is, I own a tree in front of my house. Well, I only own a third of it, and my neighbor owns the rest of it. It is a dying tree. It's huge. And every storm we have, there's damage from this tree. So I have asked if we could cut it down. It would cost about $1,000, and, of course, to do the stump and everything. And I would pay half. She refused. Now, we just had a major storm where there was damage from this tree again, but it didn't hit our property. Our properties are very close. So if she refused to cut the tree down and there's major property damage to my property, what recourse do I have, if any?
Okay. So the tree is let me go through this very basically. A tree on somebody's land that falls and damages your land is just an act of God, and they're not responsible for it as a general rule, okay?
Okay.
Now, if they do something to the tree or maintain the tree in some unnatural state, then that can become an issue.
Okay.
And to the extent that the tree encroaches over your property, in other words, that it comes over the property line, you're free to remove that encroachment, although your goal should be to do it in a reasonable and prudent fashion designed not to kill the tree itself, because you may then be responsible for killing the tree. So all those things interplay. And the general rule is if a neighbor's tree falls on your car, it's going to be your car insurance or your homeowner's insurance, because that a tree that's a naturally occurring piece of land or function of land that falls over and hurts somebody or lands on your land is not the landowner's fault.
Even though we know the tree is dead, it needs to be removed.
And that's where I say you may be able to get into a different position where you write a letter to the other side and say, your tree is dead and it is endangering us, and that creates a liability issue.
Okay, so a letter has to be written?
Yeah, it doesn't have to be, but they're going to argue notice later. They're going to look you in the eye and go, I didn't know it was dead. Nobody told me.
I see. Okay. So would you recommend that we get a formalized letter from a tree man?
It would be a great idea.
Okay.
It'd be a great idea. A tree man, and that way it's put it front and center. And the tree guy can also include in his letter, hey, by the way, here's what it would cost to take this down.
Okay.
So he can try to sell his own services while he's at it.
Okay. So let's hypothetically say we do this. She doesn't do anything. The tree falls on our property.
It can create liability issues. But if they don't do anything after the tree guy does that, I would strongly recommend, for safety reasons, that you have a lawyer then say, hey, we're going to take you to court and get a court order to have the tree taken down.
Okay. All right.
All right.
So we'll be calling you then.
All right, I hope not. I hope that they get sensible, because they risk also that the tree could harm somebody on their own property or themselves. In fact, we just heard on the news today that a tree fell and killed some woman, when it was blown over in a storm. And nothing you can do when healthy trees get blown over. I mean, they closed down Congressional today for the golf. But on the other hand, when you've got a dead tree, the only person I know that does anything with dead trees is my buddy Brent from the Stony Valley Outfitters. He likes to climb the dead trees and put his tree stands on them, which aren't so smart. But we got him fixed to that problem.
Okay.
All right.
Thanks so much, Carl.
All right. Thank you.
All righty. Bye-bye.
Bye. 540-0580, Carl Rominger here. By the way, throughout the week, 241-6070, 717-241-6070. You can get the law office. It's RomingerLaw.com, ROMINGER, law.com. Or you can go with Facebook, Carl, K-A-R-L, it's Carl with a K, and Rominger, R-O-M-I-N-G-E-R. Look me up on Facebook. There's a couple Carl Romingers on Facebook, but I'm the local one. But yeah, you can get us there. We got some great content we do only on Facebook. We also do some great content, obviously, on the radio every Saturday. So we'll be back here 1 to 3. Sheila, what's going on?
2 questions. First question about child support.
Yes.
My ex is very behind in child support. My daughter is now grown, an adult.
Mm-hmm.
However, it's through Cumberland County Court. It's, and he's in New Mexico, so it's a reciprocal agreement thing. He's now Social Security age.
Mm-hmm.
Can his Social Security check be taken for the child support that he owes?
The short answer is it can't be garnished per se, but it can be held against him. So that's worthwhile. I got 1 minute left, so shoot quick on the DUI. How does the penalty process go with DUIs? Like first DUI, you get... First DUI carries either no jail time, 1 day in jail, or 2 days in... 1 day in jail or 2 days in jail.
Okay.
Carries modest license loss of 0, 1 month, or 2 months, plus a work license for the remainder of the year on the higher two.
Okay.
And then each subsequent DUI enhances those penalties.
Okay.
All right, Sheila.
Okay.
Guys, I got to go. I'm going to set off some legal fireworks tonight. Not illegal, Art. Legal. These look legal, don't they? Anyhow, I'll be back next Saturday from 1 to 3 to answer your legal questions. In the meantime, I will be on CBS at 11:30, Face to State, CBS 21 tomorrow. So join me. Talk to you later.